Good morning. Happy Friday. We made it. So, Frauder Troll his attorney, Lou, has filed a motion to stay pending motions, pending the resolution of the motion for forum nonconvenience, and to stay discovery with the exception of a subpoena that they have out to Google because allegedly DMA has deleted a video that Hinault Frauder Troll is relying on. Again, I am impressed with Lou. Lou's doing a way better job than Vondran did. I mean, Vondran got Frauder Troll into a hole with that anti-slap motion filed by Randy. And Lou is doing what Lou can do to get Frauder Troll out of it. Again, without seeing any opposition. So this is all subject to change, but baseline gut reaction from a first-year family law attorney. I don't think one of the pending motions is the attorney fees and costs for the anti-slap. I don't think dismissing the case is going to get rid of those because it's based on California law. It was a California anti-slap motion that's recognized in federal court in California. I don't think that the dismissal, even for forum nonconvenience, gets rid of that. I don't see why the court would stay that particular motion because I don't think it's resolved on the forum nonconvenience dismissal. I could be wrong. I know that if you file a SLAP, strategic lawsuit against public participation, and the opposition files an anti-SLAP motion, and then you dismiss your case, the anti-SLAP motion proceeds, and you don't get to get out of it just by dismissing it. So, again, my gut reaction is that particular part won't be stayed. I do see the court staying discovery pending the ruling on the dismissal for forum nonconvenience. Again, I'm not saying that that's a winner motion. My gut reaction, not seeing any opposition from Randy, is that it probably won't succeed, but it could. So again, I am impressed with Lou. And yes, I know his name isn't Lou, but just to piss off Frauder Troll people, I'm going to call him Lou. But I'm impressed with him. He's doing good work. You know, this isn't a judgment that Frauder Troll's good. I still think he's a retard. But he managed to finally get an attorney who I am reasonably impressed with. You know. If I had a copyright case, I wouldn't have any issues with retaining Lou. And yes, his name is Lynn. So I'm recommending the guy. I'm not really recommending him, but I'm saying I wouldn't have any issues hiring him to represent me in a copyright case. So I should say his actual last name. His actual last name is Lynn. But I'm fairly impressed. Not saying he'll win, but he's got a chance. He's got a chance on all these motions. You always have a chance. Hashtag not always. In other words, someone sent me a copy of a settlement, an executed settlement for $40,000 for James Springer. James Springer just came up within the last month or so with $40,000 for everybody who says the auditors don't get settlements. Well, they do. before I answer the person's questions who sent it to me, let me just say that there is a non-disclosure portion of it where it was very specific on who James Springer could disclose it to, like his tax accountant, his attorney, etc. Specific people. And that was it. That was all he was able to do. And yet there is a copy apparently floating around of it. And it is a breach of that particular contract. A settlement agreement is a contract. And so in theory, the defendant or defendants, I'm not going to give anybody any indication of who it is because this particular group is full of, my audience is full of snitches who would happily tell the settling party that James Springer violated the terms of the agreement. But they can, in theory, file a breach of contract action, or I don't know if the court retained jurisdiction to enforce the settlement agreement. Because you can, well, at least in federal court in California, you can have, and in state court, you can have the court retain jurisdiction to enforce the settlement agreement. So you don't have to file a whole new lawsuit. But anyway, he could be facing a lawsuit, and that's no fun. I don't know why he would disseminate it. I mean, I understand why people send them to me. I understand that because I don't disclose them. But this one, apparently, he's been disclosing to random people on the internet, which is just shockingly stupid. Like, they could sue you and get their money back. You know what I mean? Like, what are you doing, dude? Like, do you just like to pay attorney's fees? Anyway, shockingly stupid. But the question was, in this particular settlement agreement, there are some terms like about Medicare, Medicaid, non-disclosure, things like that. It is a pretty standard agreement. The one thing that a lot of people don't understand is that in personal injury cases, Medicare or Medicaid may have a lien. If you are a Medicare or Medicaid recipient and you get injured in an accident or in a tort case or whatever, and you receive treatment that Medicare or Medicaid has paid for, then Medicare and Medicaid would have a lien in your case. It's a statutory lien, and they have a right to recover the proceeds. So, and the defendant has a duty before they pay you to make sure, as best they can. Basically, they ask you to confirm whether or not you are a Medicare or Medicaid recipient, whether or not you received medical treatment, etc. under it. Because they just have a duty to make sure that, they're not giving you the money when some of the money should go to the government to repay what the government expended in your medical bills. I do work for an attorney who had a personal injury case where, for whatever reason, I looked through all the notes. The client told him that, yeah, she was on Medicaid, and for whatever reason, the attorney didn't notify Medicaid of the potential recovery. And when he got the recovery, he just paid himself, paid the client, and went on his merry way. Well, Medicaid found out about it, and they said, essentially, we're going to go after you, the attorney, unless you pony up the money that you owe us. And the attorney couldn't find the client. She'd moved to a different state, and who knows where she went. And he ended up having to pay the money back. So, it's serious business. So that's why the Medicare Medicaid stuff is in there. It's just the defendant has to basically cover their ass make a reasonable inquiry so that they're not liable for anything if they've done what they need to do, and the plaintiff's counsel hasn't done what they needed to do to inform Medicare, Medicaid. Then it goes on to them. So that's why Medicare, Medicaid is in there. But anyway, real stupid of Springer to be disseminating this confidential settlement agreement. But, I hope I answered your questions. Thanks for watching. Have a great day.